Torts and Remedies. Negligence. Defendant has a duty of care owed to the plaintiff which the defendant breached, which is the actual and proximate cause of plaintiff's damages. Duty. Standard duty of care. Conduct measured against a reasonable person under the same or similar circumstances. Duty. Special duty. Imposed by statute or case law, which may be in addition to or in place of the standard duty of care above. Trespasser. Land occupier has a duty to exercise reasonable care to warn a known trespasser of artificial conditions that involve a risk of death or serious bodily harm. Attractive nuisance. Land occupier has a duty to exercise reasonable care to warn or protect children from artificial conditions that involve a risk of death or serious bodily harm. Licensee. Social guests. Land occupier has a duty to exercise reasonable care to warn the licensee of known dangerous conditions. Invitee. In addition to licensee requirements, land occupier must inspect for and repair dangerous conditions. Breach. The failure to exercise a duty of care owed to the plaintiff. Res ipsa loquitur. The thing speaks for itself. When the plaintiff's harm would not have occurred but for someone's negligence, the source of the negligence is within the scope of the duty of care owed by the defendant, and the plaintiff or a third party had not caused the plaintiff's harm, breach may be inferred. Causation. Plaintiff must show that the defendant is the actual and proximate cause of the plaintiff's damages. Actual cause. But for the actions of the defendant, the harm to the plaintiff would not have occurred. Thus, the defendant is the actual cause of the plaintiff's damages. Proximate cause. It is foreseeable that the actions of the defendant would cause the harm to the plaintiff. Thus, the defendant is the proximate cause of the plaintiff's damages. Intervening cause. An event that comes between the initial event in a sequence and the end result, altering the natural course of events which might have connected a wrongful act to an injury. Damages. Plaintiff must show actual damages to person or property. General damages. Awarded for pain and suffering stemming from plaintiff's damages. Special damages. Awarded for all economic expenses stemming from plaintiff's damages. Medical, lost wages. Contributory negligence. Plaintiff's contribution to their own injury is a complete bar to recovery. Last clear chance. If the defendant had the last clear chance to avoid the plaintiff's injury, plaintiff may recover damages. Comparative negligence. Apportions the negligence of the plaintiff and the defendant accordingly. Pure comparative. Plaintiff may recover a percentage of their damages even though their negligence exceeds that of the defendant. Partial comparative. Plaintiff may be barred from recovery if their negligence equals or exceeds that of the defendant. Assumption of the risk. A complete bar to recovery for a plaintiff who placed themselves at risk with knowledge and acceptance thereof. Negligence per se, ICI. Statutes which create a specific duty of care so that the violation of the statute may establish both a duty and a breach in negligence actions. Violation of a statute. Intent by the legislature to protect a class of plaintiff from a specific type of injury. Negligent infliction of emotional distress, NIED. Courts will allow a plaintiff to recover damages for emotional distress if the defendant's conduct results in physical contact or if the plaintiff was in the zone of danger. Joint and several liability. Liability which may be apportioned among two or more parties. Contribution. Joint tortfeasors are required to pay their apportioned share of damages. Indemnity. A defendant who is sued and forced to pay a judgment is entitled to indemnification against the joint tortfeasor who is primarily responsible for causing the injury. Vicarious liability. Liability for the actions of another based on a relationship between the parties. Respondeat superior. Employer is vicariously liable for the tortious acts of their employees within the course and scope of employment, and for failure to exercise reasonable care in hiring, training, and supervising their employees. Independent contractor. Generally, employers are not held responsible unless the independent contractor is involved in an inherently dangerous activity. Assault. Intentional placing of another in apprehension of an imminent harmful or offensive touching without privilege or consent. Battery. Intentional harmful or offensive touching of another without privilege or consent. Conversion. Intentional exercise of dominion and control over the personal property of another without privilege or consent. Defendant is liable for full market value at time of conversion. False imprisonment. intentional unlawful physical or psychological confinement of another who is conscious of the confinement or is harmed by it without privilege or consent. Intentional infliction of emotional distress, IIED. Intentional, extreme, and outrageous conduct by the defendant which causes severe emotional distress in the plaintiff. Trespass to chattels. Intentional interference with the personal property of another without privilege or consent. Trespass to land. Intentional entry upon the land in possession of another without privilege or consent. Transferred intent. Liability transfers from intended plaintiff to the actual plaintiff of an unlawful act actually committed. Misrepresentation, fraud. Knowingly making a false representation of material fact intended to and actually inducing a party to detrimentally rely on it, resulting in their suffering damages. Products liability. Manufacturers are liable to all foreseeable plaintiffs which result from a defect in the design, manufacturing, or warning of products they place in the stream of commerce. A plaintiff may seek recovery under the theories of strict products liability, implied warranty, or negligence. In products liability suits, there must be a proper plaintiff and a proper defendant. Head note or identify who they are and move on. Strict products liability applies to any harm caused by a product which is defective when it left the manufacturer, has not been altered prior to reaching the plaintiff, and is being used as intended or in a foreseeable unintended use, and the defendant is a commercial supplier routinely dealing in this type of good. Implied warranty. The assurance is implied in law that a product is generally fit for normal use, UCC 2-314, and where a seller knows of a purchaser's intended use, fitness for a particular purpose, UCC 2-315. Negligence. Defendant has a duty of care owed to the plaintiff which the defendant breached, which is the actual and proximate cause of the plaintiff's damages discussed below under causation. Duty. A manufacturer has a duty to inspect for and correct defects in design, manufacturing, and warning. Breach. Failure of the product to meet the expectations of a reasonable consumer demonstrated by a defect in design, manufacturing, or warning. Res ipsa loquitur, the thing speaks for itself. When the plaintiff's harm would not have occurred but for someone's negligence, the source of the negligence is within the scope of the duty of care owed by the defendant, and the plaintiff or a third party had not caused the plaintiff's harm, breach may be inferred. Causation. Plaintiff must show that defendant is the actual and proximate cause of the plaintiff's damages. Actual cause. But for the product's defect, the plaintiff's harm would not have occurred. Thus, the defendant is the actual cause of plaintiff's damages. Proximate cause. It is foreseeable that the product's defect would cause the plaintiff's harm. Thus, the defendant is the proximate cause of plaintiff's damages. Consider intervening cause, etc. from page 1. Damages. Plaintiff must show actual damages to person or property. General damages, awarded for pain and suffering stemming from plaintiff's damages. Special damages, awarded for all economic expenses stemming from plaintiff's damages, medical, lost wages. Contributory negligence, plaintiff's contribution for their own injury is a complete bar to recovery. Last clear chance. If the defendant had the last clear chance to avoid plaintiff's injury, plaintiff may recover damages. Comparative negligence, apportions the negligence of the plaintiff and defendant accordingly. Pure comparative. Plaintiff may recover a percentage of their damages even though their negligence exceeds that of the defendant. Partial comparative. Plaintiff may be barred from recovery if their negligence equals or exceeds that of the defendant. Assumption of the risk. A complete bar to recovery for a plaintiff who placed themselves at risk with knowledge and acceptance thereof. Misuse of product. An item. A party who uses a product not as intended shall not have a cause of action in product liability. Alteration of product. The alteration of a product after sale removes liability from the manufacturer. Design defect. The product was designed in such a way that it presented an undue risk of harm in normal use. There was a way to build the product safer, more practical, and at a similar cost. Manufacturing defect. The product does not conform to the manufacturer's own standards and intended design. Warning defect. Failure to warn plaintiff through inadequate instructions, warnings, labels, etc. of dangers not obvious to an ordinary user. Nuisance. Public. Unreasonable interference with the health, safety, and property rights of the community. Private. Substantial and unreasonable interference with a person's use or enjoyment of their property. Recovery for a private party is based on a showing of special harm unique from that of the general public. Defamation, PUD. A false defamatory assertion of fact which is published to a third person, understood as defamatory by that third person, and causes damage to the plaintiff's reputation. Consent. Consent is a complete defense, defamation. Truth. Truth is almost a complete defense based on a scenario in the fact pattern. Privilege. Absolute. Complete defense for official government scenarios within the course and scope of duties and discussions between spouses. Conditional. Complete defense under good faith. Privilege can be lost by bad faith or abuse. Slander per se, club. Spoken defamation regarding crimes of moral turpitude, loathsome disease, imputing unchastity of a woman, or business. Injurious falsehood. False and injurious statement that discredits or detracts from the reputation of another's character, product, or business. Interference with prospective economic advantage. Intentional, damaging intrusion on another's potential business relationship, opportunity, or employment. Strict liability. Liability imposed without regard to fault. Animals. Dangerous animals. The injury must be from the dangerous propensity of the animal. Zoos and common carriers are exempt. Fleeing an otherwise non-dangerous wild animal applies. Abnormally dangerous, ultra-hazardous activities. Activities which are not a common usage in the community, and the abnormally dangerous, ultra-hazardous activity creates a highly significant risk of physical harm even when exercising reasonable care. Nominal damages. A declaration of the plaintiff's rights and a determination that the defendant has wrongfully infringed upon them. Punitive damages. A sum of money in addition to compensatory damages to punish the defendant for willful, wanton, or malicious conduct and to deter such conduct. Defense of self. Reasonable force necessary to protect oneself up to and including the use of deadly force. Defense of others. Reasonable force necessary to protect others with whom the defendant has a special relationship up to and including the use of deadly force. Modernly, to protect anyone. Defense of property. Reasonable non-deadly force necessary to protect one's chattel. Necessity. A person is privileged to enter the land or interfere with the chattels of another if it is necessary to protect a person from death or serious bodily harm. Thin skull plaintiff. A defendant is liable for a plaintiff's unforeseeable and uncommon reactions to the defendant's act. Immunity. Traditionally, government units were not subject to suit unless they had already consented to such. Firefighters' role. Police and firefighters are banned from pursuing recovery against those rescued, as injury during a rescue is one of the occupational hazards of the job. An MBE note here. A cop returning to the station who is T-boned by a bad driver does have a case against them. Even though they are on duty doesn't mean they cannot sue and collect for their injuries by negligent folks. Emergency doctrine, non-professionals. Exempts a person from the ordinary standard of care if that person acted instinctively to meet a sudden and urgent need for aid. Good Samaritan law, professionals. Exempts from liability a person, such as an off-duty physician, who voluntarily renders aid to another in imminent danger, but negligently causes harm while rendering such aid. Balance, the measure of competing interests and appropriate offset to achieve balance. Pre-existing duty, a duty which one is already legally required to perform.